Hello, everyone. This is Debbie Malillo. I'm the Distance Learning Director for Technology Transfer Tactics, and I'll be your host for today's webinar, SBIR STTR Policy Changes, New Challenges and New Opportunities. This session is being recorded, and at the conclusion of the lecture portion, there will be a question and answer period, so feel free to submit questions using the chat form during the presentation, and we will address them during the Q&A portion of the program. This webinar is being sponsored by Technology Transfer Tactics, the monthly advisor on best practices in tech transfer and translational research, and by University Industry Engagement Advisor, the first and only newsletter devoted to helping universities expand holistic industry engagement efforts and attract corporate partnerships. I'd like to extend a special welcome to our All Access Pass attendees. Our All Access Pass is a 12-month subscription package that allows you and your staff access to every live webinar and over 400 archived programs, as well as a subscription to the newsletter of your choice. You can also take advantage of the exclusive subscriber resources such as sample agreements, policies, special reports, and more. Find out more by calling me directly at 203-467-7963 or by visiting www.techtransfercentral.com. Today's program number is 1914. And for those in the audience who have requested application submission services for continuing legal education credits, please make note of the program number, as some state bars require it for submitting attendance records. You must also complete and return the attendance form that is located on the program materials page, and a link to that page can be found at the bottom of your access instructions email. This session is also approved for certified licensing professional continuing education credits. Again, today's program number is 1914. And please welcome our panelists for today's session, Kristen Parmalee, President of PCG Incorporated, and Unimed Business Development Manager, Joe Runge. Chris and Joe, thank you so much for joining us today. The program is now yours.
Thanks, Debbie. I'm going to start off, and then I'll toss it over to Joe in just a minute. Today, again, the topic is there were some recent policy changes to the SBIR program released by the SBA on May 2nd of this year, and so we're going to talk about those. First, we'll go over the general policy updates from the Small Business Administration. Then we'll look at some changes to specific agencies. First, the National Institutes of Health, National Science Foundation, and followed briefly by the Department of Defense. Before I turn it over to Joe, I just want to give you a little context for our conversation today. Just as a reminder, the Small Business Act is part of a legislation that grants the Small Business Administration, or the SBA, control over the SBIR program. So the SBA is the one that develops the policy directives for the governance of the program. Agencies can then create their own policies, but those policies cannot contradict, weaken, or conflict the SBA's policies. So policy directives are not retroactive and apply only to funding agreements going forward. And this raises a little bit of concern or creates some gray area, as you'll hear Joe talk about IP and data rights next, because some projects in the SBA and the SBIR program were created before the policy took place, but then will be further developed going forward. And so there's going to be a little bit of gray area that might need some support from the SBA or clarification for projects that are continuations of previously funded SBIRs and STTRs. And most importantly, always check the guidelines for each agency and each funding opportunity announcement, or FOA, or sometimes called FOA. It's important to not make any assumptions in this program. So now I'm going to turn it over to Joe, and he's going to go over a couple of points. Joe, take it away.
Thank you, Chris. Thank you. Just want to make sure I had my slides up. So my name is Joe Runge. I work in the Technology Transfer Office at the University of Nebraska Medical Center. My experience is not as directly on with SBIR and STTR, and I'm certainly not engaged in the process as Chris is, but I have sort of worked with multiple licensees that have utilized the SBIR STTR process, and then I filed a couple out of our office through various misadventures in my past. My other focus is mostly on translational research, and so I run a startup incubator at the University of Nebraska, Omaha, as well as the University of Nebraska Medical Center. We have an emphasis on spinning out companies either with community entrepreneurs or derived from university technologies And the main purpose I put this slide on there is to promote a podcast that I do with my co-host. It's called Innovation Overground. You can view and subscribe to it immediately, please. But it is a tour through university innovation. And if anyone has any ideas for technologies to feature on our show, I would love to hear more about it. And I'm going backwards. So Chris graciously gave me a chance to speak a bit about data rights definition and to really look at the rights available to SBIR, STTR recipients and how and why those rights need to be protected. And so largely what we'll do is we'll go through, talk about what data rights are, why we need to talk about them, and then how do they relate to intellectual property. I come at this as a patent lawyer principally by training, and so that's usually where my mind goes. And then talk about data rights protections. So what protections does the government give to SBIR, STTR recipients? How can they be used, and how recent changes modify them? So data rights are basically the rights that small business concerns have to the work they actually produce from the funder. And I think I guess starting from a very basic level, an SBIR STTR award is fundamentally a contract between the government and a small business concern that may or may not involve a third-party research entity, but basically it is a contract to do work. And the work being done by the small business concern, kind of under standard authorship and inventorship and ownership rights, is essentially the property of the work or the property of the provider. That property, however, is subject to the contract that comes from the federal government, and that's a chance for them to be able to put conditions or utilization requirements associated with that data. And again, one of the things and the themes that will come up in how we talk about data rights, it's sort of this twisty governmental small business concern relationship that you have what are fundamentally grant-giving or research promoting agencies working with small businesses. And so that you have these two sometimes contradictory impulses. It's to create valuable startup companies, but also promulgate research so as to advance human understanding and make information available to the public. And so these data rights are essentially ways in which those two seemingly conflicting impulses can be married somehow. So I am a big fan of kind of these visual charts that sort of lay out these various ideas. And so the way that I always think about it is what are the various relationships. So starting on the left, you have the funder. So that could be the NIH, the NSF, the DOD, whatever agency is sort of giving that award. And what they're doing is they are essentially paying a contract to a small business concern. Now that can be a proper contract like you would get from the DOD or even sometimes from the NIH or NSF, or it can be a grant. It could simply be funds given to do research. But whatever it is, it's essentially a contract that's payment for work, and that's what the small business concern can do. Now, to sort of complicate things is the small business concerns can have partners. So they can subaward that to a university, for example, or to a federal research lab, or they could work with another company through a contract. But either way, the small business concern and the partners are simply to reflect two classes of creative contributors, people who produce data or intellectual property. They are employees of the small business concern, or they are employees of sort of a partner institute. And then from that work, they conduct research. So that's kind of the last purplish arrow in the middle of the screen. And so that research is the fundamental work. It's the collection of data. It's the generation of prototypes. It's the work that produces the information. And then that generates this broad thing that we're simply calling data. So that's the raw results of the research. Now that data might actually be further developed into formal intellectual property. So you may be able to take the compiled data and use that to file a patent application. You may be able to take the information produced from the work and embody that into some software, whatever, right? The point is that you have this raw version of data and you have this sort of slightly more refined version of intellectual property. And so the things to keep in mind is that there are, real entities involved at all of these different levels, right? You have the actual contract between the funder and the small business concern. You have the actual contract between the small business concern and the partners. You have the employment agreements for the authors or inventors at the small business concerns. And then you have this process of drafting intellectual property from that data. I mean, honestly, there could be a little cloud over the data as well, which is going to be like a data retention policy. So what is the policy related to lab notebooks, related to compiling information electronically? So there's all these different areas in which the small business concern, either by how it conducts business, by the way it hires people, or like the processes internally for its own research and development, can really quantify and sort of get its hands around the particular types of data that are ongoing. So to go back then to data rights, kind of having gotten the lay of the land a little bit, is that SBIR, STTR, small business concerns, they own their own intellectual property, but it's subject to the same type of rights as BIDOL. And that, again, is part of that sort of seemingly paradoxical concern that there is the proprietary nature of small business concerns. They want to own their own data so they can create value, create jobs, get bought out, whatever, right? It's a small business that needs to thrive. However, that data is produced with public funds and needs to be able to be available for the public concern. And so in addition to that, the IP that the small business concern is going to generate, which is likely going to be the valuable part of it, is also subject to publicization. This is information that the federal government wants available to the scientific community. And so it's difficult to operate a private firm in a way that uses this non-dilutive federal money but sort of has this aesthetic of general scientific publication associated with it. And so if small business concerns own their own data, right, what exactly is that data? And so the SBA has given pretty specific guidance as to what is the data that is produced under an SBIR STTR award. And that is simply recorded information that is technical in nature and that is generated under the SBIR STTR funding agreement. And so putting on kind of compliance hat, it's actually pretty easy to check the list as to what is the data that is produced and subject to the data rights of the SBIR STTR program. It is work that is produced under the contract. So this kind of gets back to that diagram, right? Making sure that those are crafted in the actual construction of that contract. So setting out clearly what the scope of work is, which should be done in the application itself, allows some initial definition of what the actual data is. That recorded information is important too, so setting a policy as to how data is recorded within the small business concern will make it much easier to claim the benefits of data rights as they're enumerated in the recent changes. And then as long as that information is technical in nature, and again, that comes back to the original application, SBIR STTR applications are research-oriented and sort of meant to be technical in nature. So in addition to that, managing IP rights within SBIR STTR is entirely possible. It is a lot like university technology transfer, and I think having that discipline makes it much more doable, but it also requires balancing that public and private consideration, which is a lot of the conversation we've had now. So what are the protections, right? Data rights now are how funders enable small business concerns to maintain that balance. They grant explicit data rights, but there are limited times that that data can be kept confidential. The additional time gives the small business concern time to complete the scope of the work, but not having to secure patent rights. So the idea is that that information will eventually be made public, but it doesn't have to be done straight away. And also provides further competitive advantage to the small business concern without having to disclose those results. And let's get into some of those recent changes. So there are three basic changes as it's related to data rights that were promulgated in the recent changes. First of all, it clarifies that data is owned by the small business concern, and it narrows the definition of intellectual property. And the narrow definition of intellectual property is really now just two formal forms of intellectual property. It's patent, copyright, and trademark. And creating a bit of a bright line between what is data and what is intellectual property allows a more process-oriented management of data rights and utilization, and sort of keeping the data raw and utilizing the data rights to protect it, and then refining that into more formal intellectual property filings or formal secret denotation or secret statements, whatever, right? The point is it's data until it's formally protected. Second, in place of renewable limited times of data rights, so in the past, data rights would essentially have ongoing renewable applications. Now there's just a period of 20 years from the date of award that those data rights can be used. They're non-renewable, they can be voluntarily disclaimed, but in that case, the government only has rights to the data. And so by creating a bright line between the data and the intellectual property, you are essentially containing what the government can eventually claim rights to. And that's important because if you are really adding value to that intellectual property, it's one less thing that could essentially undermine the exclusivity of that intellectual property. But importantly, in order to be protected, data must be marked appropriately, and if it's disclosed without appropriate marking, it must be cured within 6 months. And I think the flexibility of this provision is incredibly welcome because a small business concern, as long as they can sort of build a policy and get within a culture of marking the things that they're generating as protected data, then the government will allow for that continued protection. And so going back again to the diagram that we set out, that the guidance related to data rights changes is that, number one, the small business concern needs to clearly maintain data ownership in contracts, devise IP generation, and appreciate that SBIR provides no assistance beyond established modes of intellectual property. So what that means is as the small business concern is conducting the work under the SBIR STTR, if they can maintain data ownership from both their employees as well as clearing out how they're going to work with their partners to sort of keep that in line, it's going to be really important. But it's also going to be really important for the small business concern to have a policy as to how it generates data so it gets its arm around the universe of all the data it wants to keep as proprietary, marks it as such, or if it's disclosed without marking, sort of fix it. Oh, and I'm sorry. That's what I was stating there. So maintain proactive data management policies and identify all of that data produced under the agreement and diligently mark it. But I think there's also value before conducting the research in maintaining contract rights and IP and maintaining appropriate IP policies. So make sure that the scope of your award actually correlates to the work that you're going to do because that's ultimately what's going to define your definition, as well as making sure that your contracts with your partners allows you to maintain that proprietary data so it's actually yours so you can keep title to the intellectual property clear. So one thing also that's important is recent changes delineated between STTR and SBIR. So STTRs require the participation of a research lab or university, and it really does complicate data management due to external policy and academic culture. So coming at this from a university point of view, I think the strength of universities is that they're not overly procedural. They're very different than industry laboratories. People are sort of free to do what they want. The converse of that, though, is sort of maintaining clear policies is much more challenging in those environments. And so as small business concerns work with universities, it's very important to keep very crisp the lines between them and to have contracts there to sort of keep those policies projected into them. The other thing to keep in mind is that the STTR awards are given primarily to the SBC, which then contracts. So all those other factors can essentially be considered in those subawards, and it's important for the small business concern to be diligent that's kind of associated with it. And then just the last thing to keep in mind is that there are these sort of building blocks to create value for an SBIR STTR company. And you have essentially the work scope of the original contract, the data policy of the small business concern, and the actual data itself. And that is essentially what's going to create value in that intellectual property in the end, and a way to think in terms of how small businesses can utilize the SBIR STTR process to add value. So with that, I will hand it back to Chris.
Great. Thanks, Joe. As you can imagine, IP rights are the biggest point of contention when we're negotiating contracts between a small business and a research institution. So it's a very important point. All right. So one of the new things on the SBA directive was clarifications on Phase 3 funding. Phase 3 has always been there, but it doesn't come from the same source of funding as phase 1 and phase 2. So we often talk about phase 1, phase 2, phase 3 in the SBIR program, but phase 1 and phase 2 funds are earmarked. They're a set-aside program, but phase 3 funds are not. Instead, agencies pull funding from other pockets of money and then tag them as phase 3 to show the full pathway to commercialization. But some agencies have been less than transparent about those opportunities. And so mostly we're talking about contracting agencies where this has been a problem. And it's certainly not pervasive in the program, but when it is a problem, it's a big problem. And so this new directive is meant to clear up some of the gray area. So what the directive did was it requires agencies now to consider and document upfront whether you would have the opportunity for phase 3 work as part of the original either BAA, Broad Agency Announcement for contracting agencies, or FOA, Funding Opportunity Announcement for granting agencies. That way you know right up front if there's going to be phase 3 money pulled from another pool of money at the end of the project to support the final leap to commercialization to kind of cover the valley of death. The other thing that this did was it required the agency to specify if those phase 3 funds will be in the form of sole source procurement. They had to clarify the meaning of sole source, and now it means explicitly non-competitive contract, which they must provide if it's practical. And the agencies are now required to act in a way that is consistent with the congressional intent to support the commercialization of the STTR, SBIR developed technology by the awardee. And that section that's underlined is the real key here, because what would happen sometimes is that an agency would issue a phase 3 award and tag it as phase 3 money, but they would not include the small business that originally developed the technology. So now they need to do that with a focus on the original awardee, and they do that by referencing the awardee by name in the RFP. So if they're going to send out an RFP to primes for taking this technology to the final step and commercializing it, they must reference the original awardee in that RFP. They would require the prime to use evaluation factors that favor that original SBIR, STTR, small business concern, and they would provide incentives to primes for utilizing SBIR, STTR awardees as subcontractors. Again, this isn't a super pervasive problem, but when it would come up, typically in contracts that involved the Department of Defense, it was a big problem. So again, this is in cases where they would award contracts to large primes without including the original awardee, and now the company that developed the technology must be more clearly included and have the opportunities. I've included some text directly from the new directive below, where you can see that they clearly state including the sole source award to the awardee that develops the technology under an SBIR, STTR award to the greatest extent that's practicable. Now, the other thing that's changed is that if an agency says they can't do that, the SBA has increased the burden that's put on the agency if they choose not to issue phase 3 funding. So now if they don't issue phase 3 funding, they have to file a special report and give the reason why follow-on funding was not acceptable. If they issue a contract to a prime or somebody else and tag it as phase 3, the small business can file an appeal with the SBA, and that will stop the contract in its tracks until the SBA has time to investigate and make a final determination. All right, the next thing was also clarification on the number of phase 2 awards. Agencies often have these follow-on funding, these phase 2Bs that move technology closer to commercialization. So there are opportunities that happen after phase 2, but before phase 3. Sometimes they can be upwards of $3 million for 2 years, so it can be a substantial amount of money. What the policy directive clarified was that Phase 2 awards need to have, Phase 2B awards need to have the same guidelines and funding limits as the initial Phase 2 awards, and that agencies cannot allocate more than 5% of funds for making these awards. So why this is important is because if agencies had a pot of money and they were setting aside, let's say 20% of funds to pay these future Phase 2B awards, that limits the available funds they have for the Phase 1 and Phase 2 awards to get in the pipeline, period. So what this does is it restricts the amount of money that they can set aside for those programs. SBA also updated the technical assistance. This was a pilot program that they have since made part of the program. It's designed to provide small businesses with technical and business assistance, again, to increase the odds of successful commercialization. These technical assistance services will include hiring consultants or bringing on new team members or purchasing even subscriptions to research services that will help you make better technical decisions concerning market validation and IP. It will help you develop regulatory plans or manufacturing plans, solve technical problems, minimize risk, and develop and commercialize the technology, including IP protections. Now, this does not allow you to spend this money on the actual filings, but to develop plans for IP protection and FDA. So each agency may issue SBIR STT funds for technical assistance up to $6,500 on a Phase 1 proposal and up to $50,000 on a Phase 2. And these are pretty substantial increases. Originally, it was $5,000 for a Phase 1 and only $10,000 for a Phase 2. So they've upped the Phase 2 funds quite a bit. Now, the directive says that this should be in addition to the amount of the Phase 1 award and in addition to or included in the amount of award for a Phase 2. In preparation for this webinar, I checked with a couple agencies about how they wanted to see this on budget forms, and it turns out that each agency is handling this technical assistance request in a different way. So NIH said they don't care where you put it because they don't care how big your budget is, and NSF said don't put it in your budget at all because they want you to use their provider. So it's really important that you check with the agency if you're going to request technical assistance funds. So some of the agencies have their own vendors. Like I just mentioned, NSF has their own vendor, and they want you to use those folks, including Dawnbreaker, ICOR is what NSF and NIH use. But small businesses can also choose their own vendors. And if you do that, if you want to do that, you need to check with the agency and make sure that that's something that they'll allow. You need to demonstrate that the individual or entity that you choose to provide those services can provide those services that they're qualified. And you do that by providing a letter of support and even in some cases, a biosketch. Okay, cost sharing, these are just a couple of other, just as a wrap up on the other updates to the directive. Cost sharing is prohibited for Phase 1s, and it may not be a Phase 2 requirement. Now, agencies can take cost sharing into consideration for Phase 2, but they can't make it a requirement. They can make it a requirement for certain special awards. For example, it's typically a requirement in Phase 2B funding. You'll typically see that there's a cost share requirement for that. State matching funds is another area where really what they did was provide clarification. A lot of states provide matching funds. The state that I'm in, Indiana, provides up to $50,000 on a Phase 1. And some agencies were considering these matching funds to be duplicative funding. So you're not allowed to receive funding from more than one source, or you're not allowed to supplant other potential sources of funding with federal funds on a particular scope of work. And when these states would give matching funds, sometimes they were seen as being duplicative funds. So they clarified the directive to make sure that state matching funds are not considered duplicative. Also, you're now allowed, they clarified the directive. This has always been allowed in NIH, but now they're clarifying the directive so that on an STTR, you may partner with more than one research institution as long as one institution serves as the quote-unquote prime, which would mean they receive a minimum of 30% of the budget. Up to 60% of the budget can go out the door on an STTR. So in this instance, if you're contracting with more than one subaward institution, a minimum of 30% needs to be with one institution. On a side note, if you do contract with more than one research institution, that does open you up to the single IRB, which is the new requirement by NIH, which requires, if there's multiple sites, the sites agree on one IRB to handle all the IRB requirements for the study. You can either get all the sites to agree on a single IRB, or you can use a third-party IRB, and everybody has to submit documentation at the time of submission that they agreed to that single IRB. Finally, there was an explicit mention of priority given to proposals that address manufacturing R&D. And that's been around for a while, but I think they just kind of reiterated it. All right, moving on to NIH. So fortunately, there are, when they released their update of their omnibus, there are a number of programs that are back. First and foremost is the Direct to Phase 2. This was a pilot program a couple of years ago, but when the program temporarily lost some funding, they cut the Phase 2, and with the reauthorization, Phase 2, Direct to Phase 2 is back. One thing that NIH did to change this was previously there were special solicitations for Direct to Phase 2, and if you wanted to submit a Direct to Phase 2, your topic had to fit in one of these special solicitation topic areas. Instead, they've moved away from special solicitations and included Phase 2 opportunities in the omnibus. Now, the omnibus is the big opportunity they issue each year, and I'll talk a little bit more about that in just a second. But what you would need to do is you would need to check with each individual institute or center to see if they participate in the Direct to Phase 2 program. There are 24 institutes and centers that participate in NIH, SBIR, STTR. Not all of them participate in Direct to Phase 2. And Direct to Phase 2 is only for SBIR. They also reinstituted their Commercialization Readiness Program. This is a pilot program that provides substantial support for regulatory pathway, manufacturing support, IP strategy development. This is for Phase 2 recipients, and again, not every institute and center participates in this, but the larger ones do, like cancer, heart, lung, and blood. They typically have a CAP program. It does not cover FDA or patent filing fees. I'm sure you're seeing a theme here that money is strictly prohibited from covering those fees, but you can use it, again, to develop strategy and pathway plans. And it's designed to help overcome, again, that valley of death that's so common between Phase 2 and Phase 3. They've also launched some Phase 2 proof of concept centers. Those tend to be around particular themes or disease states. So again, check with individual institutes or centers, and it's going to be the larger ones that also have those proof of concept centers. Finally, they reinstituted their TAP program, Technical Assistance Program. They offer a niche assessment, which is great in Phase 1 or in between Phase 1 and Phase 2, which essentially does some preliminary market validation. And then they also offer their own I-Core program. It issues a separate RFA, or request for applications, and it's considered a supplement. So if you have a Phase 2 and active, you have to have an active NIH, Phase 2, and if you have an active NIH Phase 2 and they issue an RFA for the I-Core, you can apply, and it's considered an additional $50,000 supplement to your original Phase 2 award. Other good news, NIH has increased their caps. Previously, their caps were around $225 for a phase 1 and $1.5 million for a phase 2. They have allocated they have accounted for inflation and increased their caps for $252,000 for phase 1 and $1.6 million for a phase 2. These hard caps can be exceeded using a waiver. So NIH has a list of topics that the SBA has given them permission to exceed hard caps on budgets. And quite frankly, almost every topic that you could think of could be found in those waivers. And so frequently, NIH budgets exceed even these caps. Most importantly, your budget needs to be fair and reasonable for the work proposed within the timeline of the program. So if you're applying for a phase 1, you must realize that that's either a 6 or 12-month program. And so to propose a budget of $1 million isn't realistic for what you could accomplish in a 6 to 12-month time period. Participating institutes and centers or special FOAs may have their own budget caps, and those could be soft or hard. So you need to look at each particular agency that you're interested in applying to, or institute and center. So if you see under an agency, institute, if you see that they say hard cap of $225,000 and they don't reference available waivers, that means those are hard caps. If they say hard cap of $225,000 but waivers are available, that means you're allowed to exceed the cap if you can find a waiver topic that's relevant. And I do reference those waiver topics in the budget justification to let reviewers know under what waiver topic we're seeking the waiver for the budget ceiling. And again, in all cases, NIH just wants to see a reasonable and appropriate budget for the work proposed. So I talked to NIH about how they want to see the technical assistance. Again, you're allowed $6,500 in phase 1, $50,000 in phase 2. They do not require this to be on top of or even included in the budget limits. Again, they want you to request the funds you need, period. So you put this in, even if it pushes your budget over the cap, even if it pushes your budget that's over the cap already because you have a waiver, even higher, they still want to see it like that. So they stress that they want to see the funds needed, period. And then budget is always something that's negotiated at the time of award, and it's not taken into consideration by reviewers. The only question reviewers ask is the budget appropriate for the work proposed? The rest, NIH will negotiate at time of award. And then, as I talked about, if you're going to do a request for technical assistance, NIH does require a letter of support if you're using your own provider. Otherwise, you can use their resources, which is the niche assessment. But if you're going to use outside providers, you need a clear description of the scope and outcomes in the budget and then a letter of support. They've also increased their salary cap. So it's up from $189,600 to $192,300. Salary caps are used when we're talking about including, this is really only, this is very rarely relative on the side of the small business. Mostly it comes into play when we're looking at adding faculty from the university, specifically from med schools, from practicing physicians who have salaries that exceed the cap. So the cap is used, it's the maximum you can use to calculate time and effort related to salary for a key person on a project. They've moved to issue 4 omnibus solicitations. They did this again last year, so this part is not new, but in general, if you haven't looked at NIH in a couple of years, it is new. So now they issue 4 general omnibus solicitations, 1 SBIR for clinical trials, 1 SBIR that does not allow clinical trials, 1 STTR for clinical trials, 1 STTR that does not allow clinical trials. Then within the SBIR omnibus, you need to look and see if you wanted to do direct to phase 2, you need to double check and make sure that whatever institute or center you're applying to, that they support direct to phase 2. In addition, in the omnibus, you can find some institutes or centers that don't participate in either STTR or that don't participate in clinical trial, SBIR, STTR. That's all found in the omnibus solicitation. Now, NIH is trending toward issuing more targeted FOAs, either on their own as an institute or center or in collaboration with other ICs. And so there sometimes is some strategy involved in determining whether you want to pick the omnibus solicitation or a targeted FOA. The pros of picking a targeted FOA are often that they've assembled a special study section to review those proposals. So odds are, if your application involves any special, if you need people who have special knowledge, odds are they'll be on that study section that's assembled specifically for that FOA. So that's one of the pros. One of the pros might be that sometimes they have larger budget caps, but the cons can be sometimes they have smaller budget caps. And in addition, sometimes they have a smaller pot of money to make awards, which means a targeted FOA might only have 1 or 2 winners when there might be many winners on an omnibus. But sometimes it's less competitive than the omnibus, so sometimes that's a pro. And then the other thing is that targeted FOAs do expire, and frequently in the NIH program, resubmissions are required to actually achieve funding status. And if the FOA has expired, we don't have any way to guarantee that it will be renewed in time for you to do a resubmission. And so that would mean that you'd have to come back in the program, probably under the omnibus as a new submission. Another thing that is just something that I've noticed over the last year or so, resubmission used to be a great strategy for increasing your score, but resubmissions have actually been coming back with lower or only marginally higher scores than new submissions. And I've heard a lot of program managers talk about just going in as a new submission as a strategy. So it seems like resubmissions may have started to become sort of clutter in the review process. Every time you go in, you're held against a new group of peers in the review process, and competition is getting stronger and stronger. So it may behoove you to, instead of going in as a resubmission, consider going in as a new submission. Finally, one change that NIH made is special designations like women-owned business or minority-owned business are now not able to be marked on your SF424 or your cover page form. Instead, the small business concern would have to make those designations when they're registering for SAM. So you can't just declare those on your NIH forms anymore. They have to be made at the global level on SAM. All right, quickly moving on to NSF. Effective March 2019, NSF moved to what's called a project pitch submission. So now you have to submit an initial project pitch online, and then they provide some preliminary feedback. And if they think that your project aligns with their agency goals and interests, then they'll invite you to submit a full proposal. This process was designed to allow program managers to provide more specific feedback to potential applicants and help them. I think the intent was really to provide a little bit more assistance in helping applications that are a good fit for the program hone in on what the agency is looking for. And in addition, it's designed to allow the agency greater agility and flexibility when they receive and start evaluating the proposals. So they say when they receive them, they'll start reviewing them right away. The project pitch is an application that's online. The longest section is 500 words. Here are the main categories. Again, it only amounts to about 3 pages, and it's focused on a basic overview of the proposed project. So technical innovation, objectives, market opportunity, company and team, and then you let them know the topic area. Within 3 weeks, they'll let you know whether you're invited to submit a full proposal or not. And then once you submit the actual application, you are required to attach that invitation email. You could get an email that says you're not invited to submit a full proposal. Now, everybody that I have had submit a project pitch so far has been invited to submit a full proposal. So I think that my original thought was, wow, they're going to be really discerning here, but I think they're being fairly open to projects that come their way. They also moved to submission, quote unquote, windows instead of deadlines. So they have these rolling deadlines. The one that's currently open closes December 12th. It started June 15th. So it's June 15th to December 12th. This is a pilot program, and it expires December 31st. And they don't know whether they're going to continue it or not. We don't know. But so far, it seems to be going well, and so I'm sure they'll keep us up to date. They did move to even broader topics. If you haven't looked at their topics online for a while, they don't contain any descriptions anymore. There used to be a list of more nitty-gritty details of projects they were looking for. Now they're just the topics. It just says biomedical engineering. It just says energy storage. So they're very, very even broader than they were. They do have a new requirement on an STTR that the PI must be at the company. And this is unlike any other program or any other agency in the entire program, but the PI, even on an STTR, must be at the company, which means the PI at the company must be more than 50% employed by the small business at time of award, and they need to contribute a minimum of 10% effort on the project. The sub-award PI at the partnering research institution also cannot hold any equity in the company that's applying for the award and cannot receive a salary on the grant. The majority of my clients are actually universities that match me with faculty members who have spun out companies that want to commercialize technology. And so this has been a huge thorn in my side. And the two ways that we've found to sort of circumvent this or to still navigate the process using these restrictions are, first, the principal investigator at the university that does hold equity in the company does not receive a salary. So they might be on the project, but they're not going to receive a salary. However, some universities have a policy that precludes a faculty member from being on a budget and not receiving a salary. And in that instance, the faculty member has typically gone to a peer or a colleague and asked them to serve as the principal investigator on the project in a limited role requiring a 10% minimum effort, and then the faculty member who's the founder is still involved but not as a key person. This is a very quick update on Department of Defense. They have a growing number of what they're calling out-of-cycle opportunities. They call their opportunities BAAs, Broad Agency Announcements, because they're a contracting agency. These BAAs typically have really broad topics, which is the complete opposite of the way Department of Defense usually issues their BAAs. They're super fast moving, so they might have a very quick deadline, and they might move from application to contract very, very quickly. They've been having these pitch events that literally end with awards, with SBIR awards at the end of the day. So companies have been showing up pitching, and by the end of the day, they have an SBIR award. It's designed to quickly move the technology from concept to acquisition. The Department of Defense is your end customer, and most of the things that they're trying to develop in the SBIR and STTR program, they have an urgent need for. So they're trying to leverage the most cutting edge and agile technology and move it as fast as they can from lab to market. They post all of their opportunities on FedBizOps, and you can sign up to receive updates and opportunity announcements on their list. Right, I provide the email for you to sign up. Okay, Debbie, that's all I got.
Great, thank you so much. We're going to go ahead and start our Q&A portion of the program now, and if you'd like to submit a question for consideration, go ahead and post it in the public chat forum, and we'll take them in the order that they are received. We do have a question in queue. It's from Deanna, and it says, when you say the recent changes clarify that the data is owned by the SBC, Do you mean it is owned by the entity that generates it? In other words, it's not owned by the government agency?
Hi, Debbie. This is Joe. Can you hear me?
Yes, I can. Thank you.
Yeah. So the data is owned by the SBC and not by the company. So I think that the notion is, and coming at this from like a tech transfer perspective, when we have the license related to intellectual property that's produced with federal funding, we're always advised by counsel to make sure that there's kind of a margin section that rights are subject to by dole. If it's a group that is inexperienced with university licensing, it can be kind of a thing because what does that mean? It's like, well, we don't really know. And so I think that there's kind of a similar concern associated with data rights from SBIR STTR recipients. I think that the SBA has clarified that title does actually retain to the small business concern. So the small business concern owns that data. And I think that the data rights are a good step towards giving a real tactical consideration that for 20 years, that data does not have to be published. It cannot be compelled to be made public in any way. I mean, in a practical concern, I don't really know what public benefit there's going to be after 20 years for most in-process SBIR STTR awards. So, from a policy point of view, I don't know if that's terribly effective. But in terms of what the small business concern wants to be able to do, namely exploit its data and create value, getting that grant of explicit ownership in addition to the specific rights to retain that data really is kind of a combination of a right and a remedy. So yes, you own it, and here's exactly what you can do with it. So I guess to go back to the question, yes, it is owned by the small business concern and not by the government. There are some lingering rights that the government can retain, but they're not ownership rights. They're rights to eventually compel. However, those rights are nested in specific policies and specific practices that the small business concern can cultivate in order to keep its data proprietary.
Thank you very much. Our next question comes from Carrie, and it reads, is there one source from where we can get automated email on all the SBIR STTR opportunity announcements?
Well, that would be lovely, but unfortunately it doesn't exist. The best thing to do is to go to agencies and sign up for their individual listservs. There is a site, SBIR.gov, that publishes all the open opportunities, but the best, most reliable source is the agency websites themselves.
Thank you so much. And while we wait for any further questions to come in, I'd like to invite the audience to our next professional development program. This one is taking place on July 17th, and it's titled IP Audit Checklist, Best Practices to Identify, Protect, Monetize, and Enforce University IP Assets. And based on high praise received from the initial live session, we're making this program available once again as a previously recorded encore presentation. Registration includes a free audit tool, courtesy of the law firm Offit Kerman. Visit www.techtransfercentral.com and click the link under the upcoming webinars tab at the top left of the homepage for more information or to register. And I do show another question in the queue. It reads, let's see, this is from Chelsea. It reads, you can only apply for the NIH I-Corps program if you have an active Phase 1 or Phase 2, correct? Can you please comment on the timing of when you can or should apply for the assistance programs you listed?
Yeah, I'll comment on I-Corps specifically for NIH. You must have an active NIH, and I believe you actually have to have an active Phase 2, I could be wrong, to apply for NIH I-Corps. NSF I-Corps is different. NSF and NIH I-Corps, the time to apply to that is after Phase 1 and either before or in Phase 2. NSF I-Corps has different levels. We have regional nodes, which provide some sort of like a mini camp, a mini I-Corps camp, which is great to do even before Phase 1. They have the full national program, which I still think the best time to do is in between Phase 1 and Phase 2. And then they even have some larger regional programs that are run out of the nodes that are more intense than the camp, but not national. All of that designed to feed you eventually into a successful application to NSF and into a successful commercialization.
Thank you. And going back to the question regarding data, the attendee would like to clarify their question. It says, if a research institution generates the data.
Got it. That's actually a really good question. So if the research institute generates the data, the small business concern and Chris, please feel free to correct me on this because this is getting a bit out, this is me being a bit, I guess, opining more than any direct experience. But since the SBA has clarified that the small business concern sort of owns the data that they generate, it is essentially their title then under the prime award to award to the university. And so I think that the small business concern needs to be sensitive to the IP policy of the university, for example, that they're contracting with. However, they also need to be firm that the IP that is generated, the data that is generated, is something that can be sort of rolled up into the small business concern. So, for example, it's a violation. I know at our university we would consider it overreach, maybe not a violation, but overreach to require assignment of intellectual property that comes from a SBIR STTR subaward. However, there can be commercial terms that would have favorable licensing language or an agreed upon process for invention disclosure and exclusive option negotiation. But the idea is to get arms around and agree to a process ahead of time as to kind of the data and the intellectual property that is generated therefrom. So if there is a subaward to a university, you can essentially thread the needle and keep the business concerns of the small business afloat while simultaneously honoring the policy objectives of the university itself.
Yeah, Joe, I think I agree with all of that. The only time that it becomes a little bit of a gray area is that, or when there's some trouble negotiating, and we, as I said, we do that all up front when we issue the actual subcontract award, and this is the number one place where there's back and forth we've been working on one contract since April. I think we're close to getting it signed, but, what's that, 3 months? And it's all hung up on the intellectual property. Sometimes a subcontract to a university, it's almost more determined by the scope of work than anything else. So if the company is coming to the university specifically to access their intellectual property to contribute to their project, then the university should have more rights. So if they're making discoveries and contributing significantly to the technology on university property with university equipment, that's one thing. If, however, the company hires the university, for example, to conduct a clinical trial with their products that have already been developed and validated in the market, this is a clinical trial, that's something else. So it does tend to depend on the scope of work, what those rights look like, but that is the hardest point. That's the real place we get hung up in contract negotiation for sure.
Absolutely. I think, but it kind of, the slide that I put up related to data rights is there's all these gates where these issues can be clarified, and with some forethought on the scope of work from the funding agency, with clear negotiations and processes laid out in the subawards, those data rights can be very effectively managed. But the thing that's really useful in the recent change is by clarifying that the SBC is the wellspring of all those rights, you kind of know where the river starts from, and then everything else is just sort of channeling it to where you want to go.
Good point.
Thank you. Our next question comes from Ryan, and it reads, I understand there are changes to SBIR-funded PCT conversion timing. Can you comment?
Changes to SBIR what timing?
SBIR-funded PCT conversion timing.
Oh, you know what? Honestly, I cannot really comment on that. That's going to be more Department of Defense, and that level of nitty-gritty in the Department of Defense is not my area of expertise. I would not want to give you the wrong information.
Thank you. Our next question comes from Ms. Williams, and it reads, what are some ways university teams can find readily suitable small business partners to work with when they come across a topic of interest to respond to?
Boy, that's a big problem. And if I had a nickel for everybody that created a database and exchange that went unused, I'd be a millionaire. I think the best way to do that is just networking. I know that you can look up small business SBIR, STTR support programs in your state. They're going to know a lot of the small businesses. You can look at resources like your statewide PTAC, which works with small businesses. And then, I would probably turn to some of the industry groups. If you're in life sciences, I would look at the life sciences group. But that is just something that I have found best comes organically through networking.
Thank you. And our final question for the day is from Diana, and it reads, in the NSF slide, it states, subaward PI at partnering research institution cannot hold any equity in the company applying for the award and receive salary. Is this meant as neither hold equity or receive salary?
They cannot. They can be on the grant and be an equity owner in the company as long as they don't receive salary. So it's meant to be both. So that's why sometimes we're able to place PIs, faculty members as the PI, but they don't receive salary. And that works unless your institution has the policy against faculty members receiving zero salary on a grant.
Thank you very much. Again, for those in the audience who have applied for continuing legal education credits, today's program number is 1914. My apologies. Chris and Joe, thank you so much for your expertise today. If you have any final comments, go ahead and share them now. Otherwise, we'll go ahead and close the program.
Nothing else to add.
I'm going to selfishly plug that on my website, you can sign up for my newsletter, where I do send out a monthly newsletter about agency announcements and changes like this to the directives. So if you are interested in following up with those SBIR, STTR updates, you can sign up for that newsletter on my website.
Thank you very much. That concludes our program for today. We hope to see you at our next distance learning event. Goodbye.